Hello again, I'm attorney Robert Flesses. This video is part 2 on the topic of agency law, which is course 1. We're going to discuss the duties that you owe to all parties in a real estate transaction under the law. The duties that you owe are pretty much the same to a customer and a client, except when you're working with a client, you owe a duty of loyalty. Your duties are all defined in Wisconsin Statute 452.133, which means that it's the law, and if you want to work as a real estate agent in Wisconsin, you have to follow the law. Most of these duties are obvious, and I'm sure that you already know them, but you'd be surprised if you read some of the state's disciplinary orders that detail how agents fail to follow the rules. Sometimes you'll see total disregard for the rules. Sometimes you'll see that a licensee probably didn't even know the rules. That's why you're here today watching this video. The first section of the Controlling Wisconsin Statute lays down the rules regarding your duties to all parties to a transaction, okay? It doesn't matter if you're dealing with a customer or a client, the duties apply equally to both parties. The duties to all parties has 7 basic rules. Let's go through each of them. When you provide brokerage services like selling a home as a listing agent or finding a home for a party as a buyer's agent, or even dealing with an unrepresented customer, the law requires you to be honest, fair, and act in good faith. Honesty, fairness, and acting in good faith are all the virtues that you need to maintain, even if it means that you lose your commission if these virtues cause your deal to fall apart. That's pretty straightforward. Most licensees always operate under these virtues, but some don't, and those very few are the ones who tarnish the reputation of all of us. But that happens in every profession. The second rule requires you to diligently exercise reasonable skill and care in providing brokerage services to all parties. Well, what defines reasonable skill and care? Reasonable skill and care in real estate refers to the standard of care and professionalism expected from real estate agents, brokers, or property managers when carrying out their duties and responsibilities. It implies that licensees should exercise a level of expertise, competence, and diligence that's considered reasonable and acceptable within the industry. When providing services or advice related to real estate transactions, the concept of reasonable skill and care entails several key elements, and here they are. Real estate professionals are expected to possess the necessary knowledge and expertise in their field. This includes understanding relevant laws, regulations, market trends, property valuation methods, and transaction processes. You should stay updated with the changes in the industry and be capable of providing accurate and informed advice to clients. You should carry out your duties diligently and with attention to detail. This involves conducting thorough research, verifying information, and reviewing relevant documentation to ensure the accuracy and completeness of transactions. You shouldn't engage in any fraudulent, deceptive, or misleading practices. Failure to exercise reasonable skill and care in real estate can result in professional negligence or breach of duty, potentially leading to legal liability and financial consequences. Clients who believe that a real estate professional has not met the standard of care of reasonable skill and care may have grounds for filing a complaint or pursuing legal action to seek compensation for any damages incurred. The third rule requires you to disclose to each party all material adverse facts that you know and the party does not know or can't discover through reasonable, vigilant observation, unless the disclosure of a material adverse fact is prohibited by law. It's always better to practice disclosure than to not, but there are exceptions. What are some material adverse facts that are not required to be disclosed? What happens if you take a listing that's subject to a foreclosure action? Is that a material adverse fact that must be disclosed? Well, let's examine that. Here's the scenario. A person calls you to list their home. The seller discloses to you that a foreclosure action was recently filed and is pending. You did your due diligence prior to visiting the property by doing a market analysis and determined that the property's value is around $350,000. You then ask the seller, what's the balance owed on your mortgage? The seller responds, $150,000. So you determine that there's some breathing room of about $200,000 in equity or so before expenses. You take a look at the real estate condition report and determine that there are not any pre-printed questions regarding foreclosure. You only find questions related to the condition of the property. You also then look at a blank offer to purchase to see if the definition of conditions affecting the property or transaction include foreclosure actions. It doesn't. So you and your broker need to make a decision. Do you disclose that the property is subject to foreclosure in your MLS listing or any information that you distribute to prospective buyers? You need to analyze the situation. Let's analyze it. There's plenty of equity remaining in the property. There's a public record appearing on CCAP that indicates a foreclosure is in progress. There could even be a lis pendens that's been attached to the property. You determine, based upon your experience in the current market, that the home should sell at or above the listing price. And if you make the disclosure on your listing, buyers could think that they can offer much less to the seller, thinking that they can take advantage of the seller's situation. Now, some investors will look at the public record. They'll pull a title report even. Both will reveal that the property is subject to foreclosure, but it would be very difficult to determine the mortgage balance. Most prospective buyers won't go to the courthouse and pull a copy of the summons and complaint from the civil clerk of courts, because that could be too much work. Now, under that analysis that you perform, is this really a material adverse fact? I'll give you a few seconds to make the determination. Well, the answer is as follows. You could disclose the fact that the property is subject to foreclosure, but you're going to have to deal with low-ball offers. You'll probably receive low-ball offers anyway from investors. This is a discretionary decision by your broker. In my opinion, since I'm a broker too, and if I were confronted with this issue, I wouldn't disclose the fact that the property is subject to foreclosure. Why? There's tons of equity in the home. The home will sell and fetch at least the market price, and when the property closes, the mortgage company is going to get paid. And you're going to receive your commission too. So there's no problem here. But a phone call to the attorney for the lender to disclose that the property is for sale and to determine how much time remains before the sheriff's sale is confirmed by the court is going to give you a better idea how much time you actually have to get this property sold. Take the listing, get it on the market, get the ball rolling. Now, what about this twist? There's very little equity remaining in the property, and you're going to have to deal with the lender on a short sale. In this situation, I would disclose the fact that the property is subject to foreclosure and use the appropriate language in any offer to purchase. Getting back to the statute now, the fourth rule requires you to keep confidential any information given to you in confidence, or any information obtained by the broker that you would know a reasonable party would want to be kept confidential, unless the information must be disclosed under the third rule we talked about of disclosure of a material adverse fact, or is otherwise required by law to be disclosed, or the party whose interests may be adversely affected by the disclosure specifically authorizes the disclosure of particular confidential information. And this continues. A broker shall continue to keep the information confidential after the transaction is complete and after the broker is no longer providing brokerage services to the party. Let's say at your meeting with the seller pre-listing, the seller says that they had a basement inspection performed and revealed that the basement does have issues, the extent of which could be costly. The inspector says that the owner should consult with a basement repair contractor to get their opinion, but the seller tells you they didn't do that. The defect is not readily apparent to a buyer because when it rains, the basement floods. You would for sure disclose that fact because you now know about it and the buyer may not discover it through a reasonably vigilant observation of the basement. I would also attach the basement inspection report to the condition report to fully disclose, giving a prospective buyer notice and the opportunity to further inspect. Well, let's say you don't disclose it because you know that a buyer's offered price might be substantially lower than the market value due to that disclosure, and lower price means what? Lower commission. You're told by the seller to make sure that the property is sold as is because they can't afford the repairs. If the buyer doesn't perform a basement inspection and subsequently discovers the defect, then the seller will get sued and possibly you as well. As a licensee, the statute of limitation is 2 years for brokers and agents. It's 6 years for the seller. That's the time period that a buyer has to sue. Even if the seller insists that the properties be sold as is, you're still opening up the door to litigation because you still have your inspection and disclosure duties by law. Let's look at the 5th rule. You must provide accurate information about market conditions that affect the transaction to any party who requests the information within a reasonable time of the party's request, unless the disclosure of the information is prohibited by law. What type of disclosures are prohibited by law? One of them would be disclosures related to housing discrimination. The property was the site of an act or occurrence that doesn't affect the physical condition of the property or any structures. The location of any adult family home, community-based residential facility, nursing homes located near the property. All of these prohibitions on disclosures can be found in Wisconsin Stat 452.23. Well, let's get back to the rules. Let's look at the 6th rule. This one pertains to accounting for all property coming into the possession of a broker that belongs to any party within a reasonable time of receiving the property. This is self-explanatory. The final and 7th rule requires you to present offers and other documents in an objective and unbiased manner within a reasonable time of your receipt. We all know that. Well, this concludes Agency Part 2, and I'll see you in Part 3.